Yes, Ms. Criddle.
Thank you, my lord. So turning then to the interpretation of Regulation 3, and the starting point to which I'd like to take the court is Nichols itself, and it's page 616 of the authorities bundle, and it's paragraph 20. So it's making 5 numbered points. First, that the 2P regulations exist to give effect in domestic law to the directive. Secondly, it follows that the 2P regulations are to be interpreted in accordance with the directive. Thirdly, when considering what constitutes an undertaking, it's relevant to look at competition law. Fourthly, that Regulation 3.5 gives effect to Article 1C, which in turn was introduced to reflect the decision of the Court of Justice in Henker. And my Lord Justice Baker asked the question about whether or not that is really what 1C does. My Lord, you may have seen that there are 3 versions of the directive in your bundle. One is the original Acquired Rights Directive. The second, which is at page 9, is the 1998 iteration of the directive, and that's where you first see 1C, and then you've got the 2001 directive, which is the present one. And then the 5th point is making that point. The original directive doesn't have an equivalent to 1C, and that 3.5 is merely identifying something which would not be a relevant transfer in any event, even if 3.5 were not there. And then just one other point that may be helpful to pick up from Nichols, and it's at page 624 and paragraph 47. It points out that the definition of economic activity is settled, and that it traces back all the way to a decision of the Commission of the European Communities and Italy. It's about any activity consisting in offering goods and services on a given market is an economic activity. That's what an economic activity is known to be. Just for your note, Scatterlon is an employment case which uses that definition specifically in looking at what is an economic activity, and it's, for your note, it's page 552 and paragraph 43 of Scatterlon. And the point is this: not a transfer doesn't encompass every situation in which one entity ceases to carry out an activity and another entity does so in its place. That's apparent from the language of Regulation 3 itself. There has to be an economic entity. There has to be a retention of identity post-transfer. There has to be a transfer from a transferor to a transferee. The court may have had dealings with cases where you have a share purchase but no change in the identity of the employer. That's not a transfer. And a transfer, of course, only serves to transfer the employment of workers as defined in community law. It's been described as a partial harmonisation measure. But there is no principle that says everything has to be a transfer. That I can pick up shortly from the case of this court in Hunter and McCarrick. And in particular, the point is made at page 569 of the authorities bundle. And it's paragraph 23, agreeing with a comment made by Mr. Justice Underhill, as he then was in a case called Eddie Stobart. No doubt the broad purpose of 2P is to protect the interests of employees by ensuring that in the specified circumstances they go with the work. But it remains necessary to define the circumstances in which a relevant transfer will occur. And there is no rule that the natural meaning of the language of the regulations must be stretched in order to achieve transfer in as many situations as possible. You still have to apply the definition in the regulations which give effect to the directive. And in this regard, it has to be recalled that the directive and the regulations both require there to be an economic activity. It's not an option, it's a necessity. If I may just briefly, first of all, the original directive is in your authorities bundle at page 5, the Acquired Rights Directive, and that recognises that there is both a social and economic purpose to the directive. It's about ensuring the functioning of the common market, and it's in the preamble, the first paragraph that records whereas economic trends are bringing in their wake at both national and community level changes in the structure of undertakings and so on, whereas it is necessary to provide for the protection of employees in the change of employer, and then dropping down, whereas these differences can have a direct effect on the functioning of the common market, the directive is not a purely social construct in the sense of protecting employees. It's protecting employees to a purpose, namely that the common market is thereby enabled to function. And that is why we say that it's a false dichotomy that the claimants seek to draw between competition law and employment law, because both are concerned with a proper functioning of the common market. And then Article 1 is that the directive applies to the transfer of an undertaking, business or part of a business to another employer as a result of a legal transfer or merger. That the current directive is at page 14 of the authorities bundle. And it makes the point, and this is at numbered paragraph 8 of the recital, is that the directive is in order to ensure legal security and transparency, clarification in the light of the case law, but the clarification does not alter the scope of the original directive as interpreted by the Court of Justice. And it's in this directive, and in fact in the previous 198, does one sees, and this is at page 15, letter C, the directive applies to public and private undertakings engaged in economic activities, whether or not they're operating for gain, and then it goes on to say that administrative reorganisation and so on is not a transfer. So there is a need for an economic activity, and you can't get away from it. The claimants have included the case of C.J. Fry in the authorities bundle, and of course upholding the judgment of my Lord Justice Singh in the Court of Appeal in that case.
No, I don't think it was just me.
Not just you, of course.
The judgment of the court.
Indeed. But it's a case which says that when you are looking at regulations, it's a question of domestic construction. But where there was no dispute in the Fry case that the regulations were doing anything other than give effect to the purpose of the directive. And Uber, in fact, is a case to like effect, because what happens in Uber on the question of domestic interpretation, the EU concept of worker is being used to inform the domestic interpretation of who falls to be protected as a worker, that there's just no distinction, no difference between domestic interpretation and the directive.
Yes, I think there are two principles at play in this context. One is a very old principle indeed. Certainly throughout the period the UK was a member of what became known as the EU, originally the Common Market, which is that if domestic regulations are enacted to implement a piece of EU legislation, then domestic courts should strive to interpret the domestic regulations so as to be in conformity with the originating legislation. And that it has nothing to do with domestic law. But I think that there's a second principle which perhaps has become more clearly articulated in domestic case law in the last few years. I personally think this is always our approach, but some people don't share that view. We've now made it clear, and Fry is a recent example, Uber is another, that there is no distinction between the literal interpretation of words and a purposive construction.
Yes.
These are not two distinct methods of construction. There is a single unified method of statutory interpretation in domestic law, whether or not you're giving effect to EU legislation, which is that all words take their meaning from their context and having regard to their purpose.
Yes.
Because every piece of legislation is enacted for a purpose.
Yes.
The legislator doesn't act because they feel like writing some words down. They're trying to achieve something. And so the modern approach, which has been clarified, but I think it was always there actually, is that the true interpretation of legislation is its meaning in the light of its context and its purpose.
Yes.
I think that's all that Fry is saying, but I think where the appellant relies on it, if I've understood the submission correctly, is that to some extent the 2P regulations went further than the directive required, and therefore their argument is that we should give the 2P regulations a broad purposive construction to achieve their effect, whether or not they're trying to implement the directive.
Yes. Well, as to that, I don't disagree, my lord, with anything you've said about the purposive approach. But of course, when you're looking at the purposive approach in the context of regulations to give effect to the directive, then the purpose you're seeking to achieve is conformity with the directive. What you have with the regulations is there's a dichotomy between Regulation 3.1a, which is what this case is about, and which is no more and no less than the implementation of the directive, and Regulation 3.1b, which is not what this case is about, which is a purely domestic construct. So if it is sought to be argued by the claimants, well, 3.1b is a domestic construct, therefore in some way that is relevant to 3.1a, well, no is the answer to that, because 3.1a does no more and no less than implement the directive. And there is no argument here that the regulations, that is to say 3.1a, fail to implement the directive in the sense that the regulations purport to restrict the scope of the directive. And so in those circumstances, you are giving effect to the directive unless it is evident that Parliament has chosen to expand Regulation 3.1a beyond the scope of directive, what is termed gold plating. But there is nothing in Regulation 3.1a which indicates that Parliament intended to go beyond the scope of the directive when looking at that classic transfer. There is a difference only when one comes to Regulation 3.1b, which is a domestic construct. And just briefly in relation to that, if I may, first of all, what you do have in the authorities bundle is the explanatory memorandum as to how 3.1b came to be part of the 2P regulations. The memorandum starts at page 23. And paragraph 3.1, there is reference to the power in section 38 of the Employment Relations Act, which empowers the Secretary of State to make provision by statutory instrument for employees to be given the same or similar treatment in circumstances falling outside the scope of the Acquired Rights Directive. And then at 3.2, section 38 is used restrictively. It is used principally to make regulation 3.1b, which applies 2P to what are described as service provision changes, which include situations where a client business outsources or contracts out to a contractor. So 3.1b is a domestic construct. That is what is added in over and above the directive. And then the authors of the explanatory memorandum at page 25, paragraph 7.2, summarise the main changes to be affected by the revised regulations are A, bringing a wider range of service provision changes, i.e. contracting out, and similar exercises involving business services within the scope of the regulations. It has never been suggested by anybody that the 2006 regulations did anything to change the definition, the core definition of what is a transfer as provided for by Regulation 3(1)A. And it's in that context that we don't quite understand the reliance that the claimants seek to place on the draft that predates the regulations, which looks at the possibility of exempting procurement from a 3(1)B transfer, because with respect, 3(1)B itself is an extension from what would be a transfer for the purposes of 3(1)A. The government is only looking in the regulations at expanding the scope of transfer to include service provision changes. It is not and never has looked at expanding the core definition of a transfer in 3(1)A, which gives effect to the Acquired Rights Directive. And therefore, when one is looking at 3(1)A, you have got to look at and you have got to interpret correctly, we say, the necessity for there to be an economic activity. You have, and I won't take you to it because it's so familiar, you have the Vodafone 2 case, which says that interpretation can't be inconsistent with a fundamental or cardinal feature of the legislation. You cannot read Regulation 3(1)A as if it didn't require an economic activity in order to bring something within the scope of a transfer, which is not an economic activity.
Can you just have the reference?
Yes, of course, of course. It's pages 478 and 479 of your authorities bundle and paragraph 38. So with those observations in mind, I wanted, if I may, to turn to Fennin itself. And we say that Fennin is a limited extension of the case law as to the scope of what amounts to an economic activity. Ms Matraghi insisted to you that Nichols had taken Fennin further by talking about commissioning and talking about services. But with respect, there is no principal distinction between buying goods and buying services, or commissioning, if you like. In both of those scenarios, you are concerned with purchase, you are not concerned with supply on a market. I'm afraid I am going to have to ask the court to look again at Fennin, because it is, we say, an important decision. In fact, it's the cornerstone of the claimant's case. First of all, if I may, the decision of the court of first instance, page 290 of the authorities bundle, and paragraph 1. So the complaint was about an abuse of a dominant position within the meaning of Article 82, what is now Article 102. So the relevant complaint was that the 26 bodies or organisations, including 3 ministries of the Spanish government, were guilty of an abuse of a dominant position within the meaning of Article 82. Now, the reason I point to that is because those were the undertakings with which the court was concerned. It was not the case that the court was looking in some unstructured way at the Spanish healthcare system. It was looking at these 26 because they were the undertakings that were said to be guilty of the abuse of a dominant position. And then turning forward in the decision of the court to page 297 and to paragraph 36, the court says in terms, it's the paragraph that starts in this connection, it is the activity consisting in offering goods and services on a given market that is the characteristic feature of an economic activity, not the business of purchasing as such. That is what the case law consistently says. And then 37, consequently, an organisation which purchases goods, even in great quantity, not for the purpose of offering goods and services as part of an economic activity, but in order to use them in the context of a different activity, such as one of a purely social nature, does not act as an undertaking simply because it is a purchase in a given market. And the question that was posed by my Lady Justice Elisabeth Laing at the beginning of the morning, well, what if you've got a charity that is doing nothing of an economic nature? Is that, but then it's not the exercise of public power either. Does that fall within the ambit of the directive? Well, no is the answer to that, because if you are doing something of a purely social nature, i.e. something which is not economic in character, then it is not an economic activity for the purposes of the directive, and therefore for our purposes not for the regulations either. And then over the page again, if I may, at paragraph 40, the court says that it follows that the organisations in question do not act as undertakings when purchasing from the members of the applicants association the medical goods and equipment which they require in order to provide free service to SNS members. Fennin was about a case in which the purchase and the supply happened by the same undertakings, and it was the undertakings that were relevant for the purposes of the complaint, because that was how they fell within the scope of Article 82, now 102. Then turning on to page 328, and that is the opinion, forgive me, of the Advocate General. And it's about halfway down, AG 65. On the contrary, says the Advocate General, as the judgment under appeal rightly pointed out, a purchase falls within the scope of competition law only insofar as it forms part of the exercise of an economic activity. That means the provision of goods or services on a market. And then finally, page 332, the judgment of the court in Fennin. The argument before the court in Fennin, and this is paragraph 17, there were two parts. By the first part, Fennin said that the court had got it wrong by failing to consider whether purchasing is itself an economic activity, which may be dissociated from the services subsequently provided. So Fennin was saying, well, it doesn't matter that the delivery of healthcare services in that case is a non-economic activity. You can look at purchasing in and of itself, and that can be an economic activity. And then paragraph 18, that was the second part in the alternative. Fennin maintains that the Court of Justice should have considered whether purchasing is economic on the ground that the subsequent activity, namely the provision of medical treatment, is itself economic in nature. And then when it comes forward to the appeal, the court decides, and this is paragraph 22, not to deal with the second part of the single plea, basically because you haven't raised this point before. But then going on to look at the first point, paragraph 23, Fennin was arguing that economic activity had been defined too narrowly, holding that that activity necessarily consists of the offer of goods or services and excluding all purchasing activity from that definition. So they said purchasing itself should be regarded as a economic activity. Paragraph 24, the Commission says, no, we don't agree. It's placing goods and services, which characterises the concept of economic activity, not purchasing activity as such. That those are the battle lines. And then the court, and this is over the page, paragraphs 26 and 27, they endorse the judgment of the court of first instance. There is no need to dissociate the activity of purchasing goods from the subsequent use to which they are put in order to determine the nature of that purchasing activity. The nature of the purchasing activity must be determined according to whether or not the subsequent use of the purchased goods amounts to an economic activity. So commissioning is not an economic activity because that is the purchase of services. Whether commissioning can be an economic activity is defined by subsequent provision. If the subsequent provision is an economic activity, so is commissioning, but if it's not, it's not. But Fennin was a case about where the purchase and use was by the same undertakings, because that's what was relevant. And the appeal fails because the provision of services by the undertakings in that case was non-economic. So where does that leave us?
But just before you answer
Yes.
that question, can I ask you this?
Yes.
You have, I think so far in your submissions, used the words purchase and commission interchangeably.
Yes.
Whereas the appellant this morning was careful to distinguish those and submitted that Fennin is only about purchase, and Mr. Justice Lavender was wrong in Nichols.
Yes.
Suddenly to bring in the word commission. What's your response to that submission?
As to that, I say this. Fennin, yes, is concerned with the purchase of goods, but commissioning is the purchase of services. And we say there is no principled distinction between the two. What is an economic activity is to provide goods or services on a market. The corollary is that the purchase of goods or services is not. There's no principled distinction, we say, between purchasing things, which is what Fennin is concerned with, and purchasing services, which is also termed commissioning. That's what we say to that. So looking at Fennin itself and where it leaves us, that the court does not depart in any way from the settled position, both as a matter of competition and employment law, that economic activity requires providing goods or services on a market. That's what an economic activity is. And purchase of goods in that case is not an economic activity, but we say equally, purchasing services, commissioning is not an economic activity either. You are buying things, you are not offering anything on a market. You're not offering goods, you're not offering services. And what Fennin does is to permit purchasing to become an economic activity if the use to which the purchaser, or here the commissioner, puts the goods or services is economic. But we say that Nichols is absolutely right. Of course, it's a matter for this court, it's not bound by Nichols. But we say that Nichols is absolutely right in how it interprets Fennin. What it says, and this is at page 623, paragraph 42 of the authorities bundle, where it says, the purchasing or commission of goods or services cannot in itself constitute an economic activity. I'm pausing there, but that of course is right, because what is an economic activity is offering goods or services on a market. Even if Fennin didn't exist, that's what all of the case law says is an economic activity. What Fennin does is introduce an exception to that position in the case of number 2, where a body which supplies goods or services on a market is carrying out an economic activity both in supplying those goods or services and in purchasing goods or services for the purpose of that supply, because it is the economic nature of the supply of goods and services that enables you then to determine that the prior purchase of the goods or services is itself economic. If not, then you default to purchasing goods and services is not an economic activity.
Can I ask you this? And again, it may be that we're going to have to deal with this at the level of court
Yes.
rather than authority. But I'd like your help on what the relevant instances are. I think one of the points that's being made for the appellant is that the way in which a health service operates has changed significantly over the last few decades. So, at the risk of oversimplification, at one time you could have a model where you have a state body which does things for itself. So, doctors, nurses provide medical services, and it's all done by a state body. But you could develop that model and, in effect, create a market.
Mm-hmm.
It may not necessarily be with a view to making profit,
Yes.
but I think we know that doesn't matter. So now the body doesn't do the operations or provide the tablets itself to patients,
Yes.
but it asks a number of potential competitors to compete for that privilege. And I may be wrong, but I think that's what's being got at. That's what's meant by commissioning. Is not simply that you're buying it, you're buying something, whether it's goods or services, but that you are operating in a market because you're not doing the operations yourself anymore. Now, whether or not that's this case, let's forget about that. Okay?
Yeah.
But at the level of principle, would you accept that comes within the definition of economic activity, or would you deny that it does?
I would say that that's not commissioning. The example that you just posed to me, if you are taking it at the level of principle for a moment, if you are the healthcare body that supplies tablets to patients, or you're the healthcare body that supplies, and the example that was used with hip replacements, you are providing a service to patients. And if it were to be concluded that there was a market for those services, the provision of tablets or the provision of hip replacements, then that would be an economic activity because you'd be offering a service to patients on a market. But that is not commissioning. What the CCG, what my client at one point, there's been many changes since, but what my client does is commission services. It doesn't do anything. It doesn't supply medical services to the public. It commissions, it buys in, it has the responsibility for buying services which are then delivered by different entities.
When it buys in there, it doesn't just go to the yellow pages and pick an entity. It negotiates, it investigates, it considers various options before choosing which entity is going to commission.
Well, it has, of course, my lord, a responsibility for ensuring that it selects an appropriate entity, but it is still, what it is doing, it's charged, it has the responsibility of ensuring that appropriate healthcare provision is made in its area. And then to do that, it buys services from others, but all it does is buy. It doesn't offer anything. And that's where we say that the distinction falls to be drawn, because it's not offering goods or services on a market. That is the acid test. That is the thing that means that it is not engaged in an economic activity, which may, as my Lord Justice Singh put to me, put it in a different category from the hospital that is providing tablets or carrying out hip replacements. They are providing services to the public. My client is not. That's not what it does. It is a purchaser. It is not a supplier, and that is why it is not engaged in an economic activity. And because it's not engaged in economic activity, then it cannot be a transfer, because a transfer requires that it is engaged in an economic activity. And Fenin only provides that extension from supply into the territory where you have supply and purchase for the purposes of that supply by the same undertaking. And as a matter of common sense, even if that were not so, how could it be otherwise? I say rhetorically, because for the purposes of the 2P regulations, you are asking yourself, what does the transfer rule have? What does the transfer rule do, which may or may not be capable of being transferred to a transferee? You've got to look at whether the transfer rule is engaged in economic activity. There's no sense to an idea that you can aggregate what the transfer rule does with somebody completely different at some point along the economic chain, and then say, well, because somebody does something which is economic in character, that serves to clothe you with being an economic activity as well. That is hopelessly uncertain, and that is not what the regulations provide for. The regulations require you to locate an economic activity being done by the transferor. And we say that when you're looking at commissioning mere purchase, then that is not an economic activity. Fenin has been followed in a case, the case of Selex. It's a competition law case, but I do need to touch on it in light of the emphasis that's been placed on the principle of solidarity, both in the claimant's written argument and also orally today. Selex, I can deal with it by going first of all to page 460 of the authorities bundle. Forgive me, I probably should first of all just go to 400 just so you can see what Selex was about, because Selex wasn't about healthcare or anything of that kind. At 400 H3, Selex was active in the air traffic management system sector, and it lodged a complaint alleging an abuse of a dominant position by Eurocontrol. So this Selex is sort of Eurocontrol number 2. And the appellant alleged distortions of competition stemming from the management of intellectual property rights governing contracts for the development and acquisition of prototypes and from assistance provided to national administration. So that's what the case was about. And then at page 460 is the relevant part of the judgment of the court, the judgment dealing with a lot of different points. But at 101, Selex had argued that Fenin was not relevant because, they said, there is no element of solidarity present in the activity in question, and because it was not a solidarity case, it wasn't about social activity, then they said that Fenin couldn't apply. And first of all, at 102, the court says that the court of first instance didn't err in law in referring to Fenin, and they say at the bottom of the paragraph that the court of first instance correctly concluded that the fact that technical standardisation is not an economic activity means that the acquisition of prototypes in connection with that standardisation is not an economic activity either. It's the corollary. If the use which you make of the goods, if the offer of goods or services is not economic, then the purchase can't be economic either. They have to go together. And then 103, secondly, the court of first instance was also fully entitled to reject the appellant's argument that that reasoning could not be transposed to the present case, that is, the reasoning in Fenin. That reasoning can obviously be applied to activities other than those that are social in nature or are based on solidarity, since those factors do not constitute conditions for the purpose of determining that an activity is not of an economic nature, but are simply factors to be taken into account. So it isn't about solidarity. It is about whether or not what you are concerned with is or is not an economic activity. Then I wanted to make a couple of references to the academic material. First of all, on that point about non-economic activities, page 833, if I may, please, the extract from the book by Wish and Bailey. Where they are looking at this question of what doesn't fall within the scope of the directive. Number 3, activities that are not economic. 3 activities have been held to be non-economic. Those provided on the basis of solidarity, the exercise of public powers, and procurement pursuant to a non-economic activity. So it recognises that public power and economic activities are not the only 2 possible categories. You can have activities which are non-economic because they're provided on the basis of solidarity, or because it's procurement pursuant to a non-economic activity without also being the exercise of public powers. And Fennin is identified by the authors at 835 as an example of the last of those categories. Fennin, procurement that is an ancillary to a non-economic activity is not
this,
economic.
what I used to know as wish on competition law. Is that what it comes from?
Yes.
Yeah. Can I just, this is not a criticism
No.
at all of anyone. So I know everyone's worked very hard, everyone in this courtroom has worked very hard. Can I just say for future reference that it is helpful if a textbook is being extracted from in a bundle of authorities, if we can have the title page, because
Yes.
then we can see which edition it is, when it was published.
Yes, of
things
course.
that sort.
And then page 819 is the article by Prosser. We were taken to the paragraph that starts at first sight, but I wanted to look at the paragraph that precedes that. The one that also says at first sight, but says at first sight, this decision seems to mark a major change from the better care decision, so referring to Fennin. But then it goes on to say, and this is 4 lines down, it may be possible, however, to distinguish the 2 cases in a way that would result in compatible principles. It should be remembered that in better care, the trust that was purchasing services from the private provider itself provided care services. Thus, it was in competition with a provider in the market for care services, not just for purchasing. Therefore, the trust was engaged in an economic activity, not just in purchasing, but also in the provision of services themselves. They're doing both. This was the understanding of the Fennin decision, subsequently adopted by the Office of Fair Trading, which announced that it would close cases alleging infringements of competition law concerning public bodies that were only engaged in purchasing in a particular market and not engaged in the direct provisions of goods and services in that market. So for what it's worth, the OFT agrees with the respondent, which is that purchase on its own is not capable of giving rise to an infringement of competition law, because you are not supplying anything on a market. You're not supplying goods or services on a market. It said Fennin is a competition law case, and it's not a case under the directive, and that is true as a matter of fact. But it has never been suggested, either at European or at domestic level, that the meaning of economic activity changes depending on whether you're looking at it for the purposes of competition law or for the purposes of the directive or TUPE. And I've taken the court already to the reference, what are said to be the uncontroversial propositions in Nichols. But the tracing through of how competition law and employment law come together on the concept of economic activity, we deal with at paragraphs 25 to 30 of our skeleton, and I'm certainly not about to go through that detailed material again. But just a couple of references that I wanted to pick up, if I may. First of all, Scatterlon, which, if you like, is the culmination of that journey. And it's at page 552 of the authorities bundle.
So
552, my lord. And just at letter C, the court is dealing with the existence of an undertaking within the meaning of Directive 77/187, which is the original Acquired Rights Directive. And at 42, they look at what an undertaking is, any economic entity organised on a stable basis, whatever its legal status and method of financing. And then at 43, the term economic activity appearing in the definition given in the above paragraph covers any activity consisting in offering goods or services on a given market, referring to the Ambulance Glockner case, the Aéroport de Paris, and then Ministerio dell'Economia. They are all competition law cases, and they are all competition law cases being used by the Court of Justice in order to define what is an economic activity for the purposes of the directive. As I say, this is the end point of the journey that we deal with at paragraphs 25 to 30 of our skeleton. Yes, of course.
Is there a definition of economic activity somewhere in the directives that relate to competition?
No.
I seem to remember when you were going through the cases, you picked up a reference to the definition in the competition cases being the same as the definition in the TUPE cases, and I should have asked at the time, but it's just popped into my head in the context of the points you're making now.
I think, my lady, that the answer to your question is there's no definition in the text of the directives,
Right.
but the way in which the court has interpreted economic activity is in the sense that is identified there at paragraph 83.
Okay, so
I
it's a matter
think
of
that the-
interpretation.
I think that the source might be Ambulance Glockner, but I'm sure I'll be corrected if I'm wrong about that. And I've taken the court already to the preamble to the Acquired Rights Directive, which talks about the object of the directive being to ensure the functioning of the common market. And I just wanted to make that point then also by reference to, in the competition law context, it's page 219 of the authorities bundle, a case called Crehan. And at paragraph 20 of page 521, it makes the point that Article 3G of the treaty, Article 85 of the treaty, constitutes a fundamental provision which is essential for the accomplishment of the tasks entrusted to the community, and in particular for the functioning of the internal market. There is not a tension between what competition law, European competition law, is seeking to achieve and the directive. Both are seeking to observe, to ensure the proper functioning of the common market.
That last passage.
Oh, I'm so sorry, my lord. It's page 219 and paragraph 20.
Oh, sorry.
It's essential for the accomplishment of the tasks entrusted to the community, in particular for the functioning of the internal market. And then finally, before I turn on to the grounds of appeal, I made reference to it, but just to pick up Henker, and it's page 161. And this is, Henker is the source for regulation 3.5. And this is the judgment of the court in Henker. At paragraph 13, the reference to the preamble to the directive, and recognising that the directive sets out to protect workers against the potentially unfavourable consequences for them of changes in the structure of undertakings resulting from economic trends at national and community level. So if you are engaged, if your employer is engaged in economic activity, you're liable to be affected by the winds of economic trends. Consequently, they say at paragraph 14, the reorganisation of structures of the public administration does not constitute a transfer. And then at 17, it appears that in the circumstances to which the main proceedings relate, transfer carried out between the municipality and the administrative collectivity are related only to activities involving the exercise of public authority. Even if it is assumed that those activities are aspects of an economic nature, they could only be ancillary, and that's the point that we canvassed just before the short adjournment, is that if what you're doing is exercising public authority, the fact that you may do some ancillary things of an economic nature does not mean that Article 3.5 does not apply.
I thought I may have completely misunderstood this case, I'm afraid. I thought ground 4, amongst other things, is a complaint that actually, if an ancillary activity is economic, that can be enough. They should have looked at that.
Yes, well, it rather depends on, it depends on how you look at it. We say if you fall squarely within 3.5, the fact that you do ancillary things which are of an economic nature matters not. If you do not fall within 3.5, then you do have to look at at the nature of the activities that you do, and you have to ask yourself the question: are those economic in nature? And without wishing to steal Mr. Ross's thunder, what we say in relation to ground 4 is that the tribunal concludes essentially that nothing that the CCG does is of an economic character.
And that's reflected in the language of regulations, or I can't remember which bit, but there's a reference to ancillary. That's Mr.
Yes.
Ross is nodding.
Yes,
and he knows what I mean, even if I don't know what I mean.
He does. And my lady, you are right to say that I think it's regulation 3.4 from memory says core or ancillary. You can have a transfer whether your economic activities are core or ancillary. And then in Nichols itself, there's a whole exploration of, well, what does that mean when Henker itself permits of ancillary activities which don't bring you outside of 3.5, and Mr. Kavanagh, as he then was, comes up with a very clever idea which finds favour with the court, which is to say this, that if you have to read it as a whole, and therefore if you are within the territory of 3.5, then ancillary activities don't take you out of 3.5, but if you're not, then you do have to look at whether or not all of the activities have an economic character, be that core or be that ancillary. With that in mind, I wanted, if I may, then to turn to ground 1, which is both that Fennin is right and applies, and also that Fennin, whatever it says, does not apply. And here we see this, the ambiguity in the approach of the claimants towards Fennin. But to deal with the primary case, that they say Fennin both is right and applies, which was their case before the tribunal, and as I say, at least in written form, before the EAT. We say that Fennin is right and it does apply, but it doesn't help the claimants, because Fennin only extends the definition of an economic activity where you have the purchase and supply being done by the same undertaking with which you are concerned for the purposes of your inquiry. And whilst the facts of Fennin are undoubtedly different to the present case, it doesn't assist the claimants, because the court in Fennin was looking at whether the healthcare bodies that were complained of were undertakings. It's not some sort of general inquiry into the nature of the healthcare system in Spain. And we say that Fennin neither requires nor permits an inquiry into the general character of the healthcare system. The question that the tribunal or court has to ask and answer is this. You have to look at the undertaking or undertakings complained of. And then you have to say, does that undertaking or do those undertakings amount to an economic entity for the purposes of Regulation 3.1a as defined by 3.2? Do they do an economic activity? You're not looking to anybody apart from the putative transferor, because it's the transferor that's capable of transferring, not anybody else. And that question, we say, is not answered by reference to the solidarity principle. That is an example only of where an entity will be engaged in non-economic activity, and Selex confirms that Fennin is not restricted to social or solidarity cases. And then in the skeleton argument for the claimants, a number of assertions are made about the nature of healthcare in the UK, and in particular, for your note, it's page 29, and it's Roman numerals 4 and 5 and 6, but none of that is grounded in the findings of fact of the Employment Tribunal. So it said, for instance, that users of healthcare services could decide whether to access NHS services. It said that commissioning of healthcare services is undertaken by NHS entities as well as by private entities. Private and other providers and NHS providers may be commissioned to provide local healthcare services by an NHS CCG. None of that is in the findings of fact of the Employment Tribunal. It's not common ground. In the absence of any appeal against the findings of fact of the Employment Tribunal, including you failed to make findings on things that we say you should have made findings on, that is not, those are not matters that the claimants can pray in aid in support of their argument as to how to interpret the activities of what it is that the CCG does.
I'm so sorry to interrupt. Could you tell me what paragraph number you're
Oh,
referring
yes, I'm
to?
so sorry.
Because my
It's,
printout is at a different page now.
of course, it's page 29 and it's your Roman numerals 4, 5 and 6.
It's, I don't have the same pagination.
Internal page 11.
Thank you.
And then Fennin does not say that purchase is an economic activity. On the contrary, it says in terms that purchasing alone is not an economic activity. And it's then said that it is, quote, an unwarranted gloss for the respondent to say that a single commissioning entity must itself be supplying the commissioned goods and or services on a market. Well, no, it isn't. It is actually the nature of the inquiry. The claimants have to be able to link the purchase to the offer of goods and services on a market, because failing that, then purchase does not bring them within the Fennin extension of what amounts to an economic activity. And then finally, it said that this question of what is and isn't an economic activity is a derogation. Well, with respect, it's not. We are concerned when we're looking at an economic activity with the nature of what it is the CCG does. And if what the CCG does is not an economic activity, and we say it's not, then you don't fall within, you don't qualify because it is not a relevant transfer. It's then said in the alternative, well, Fennin doesn't apply to the present case because this is an employment case and Fennin is a competition case. I've taken the court to Scatterlon. You've got the references in our skeleton argument to how the case law brings together economic activity, both for the purposes of competition law and employment law. The Court of Justice simply does not recognise a difference between what amounts to an economic activity for the purposes of each. And so we say, if Fennin applies in a competition context, Fennin just as well applies in an employment context, because economic activity means the same thing in both contexts.
And that's not just a technical point on your submission. It is to some extent reflective, you say, of the fact that even social legislation like GP protection is in part a harmonisation measure.
Yes.
Because otherwise you would get distortion of competition.
Yes.
In the single market.
Yes. Yes, absolutely, my lord. Yes, that is so. And then if you weren't with us on that argument and you were to say, well, Fennin doesn't apply because it's a competition law case, then the claimant's case is completely untethered to any case law which has recognised purchasing as an economic activity. And in that situation, the court is thrown back on the definition of economic activity, as I think emanates in Ambulance Glockner, which is that an economic activity is the offer of goods or services on a market. So if the claimants cannot rely on the Fennin extension, they have nowhere to go, because what the CCG does is not to offer goods or services on a market. And then there's the point that both, as I say, both competition law and employment law are looking to the same end.
You would accept, would you, that you can fall within that definition of economic activity
Yes,
as the offer of goods and services on a market,
yes,
where in fact you don't have to pay?
correct. Yes.
That's like a strange kind of market, but there it is. That's what the case law says.
Oh, I accept, my lord, that what is offering goods or services on a market, it is wide, but there still has to be the offer of goods and services on a market. If you don't, then you certainly fall the wrong side of the divide.
Yes.
On the premise of the market may well be that there are other people in the market who are doing stuff for
Yes.
money.
Because absolutely, my lady, because an example might be an NHS trust will provide you with your hip replacement, to use Ms. Matragi's example, for no
This
money.
is one very close to home.
Whereas Spire, for example, might charge you £10,000. So but there has to be a market in which you're participating by offering goods and services. And really, when the alternative argument on ground one shades very much into ground two and the question of interpretation. But whichever way you look at it, the claimant's argument essentially involves ignoring the wording of Regulation 3. They essentially ask this court to ignore the fact there's a need for an economic activity in service of an appeal to the purpose of the regulations. And Hunter shows you clearly, Hunter McCarrick, which I referred to earlier on in my submissions, shows you quite clearly why that is wrong. You have got to have a principled approach of identifying what is a transfer, and you can't answer that question by simply saying, well, the purpose of the 2P regulations is to protect employment. There's a question of whose employment is it supposed to protect.
Yes. So, for example, if what you were talking about is the Department of Health,
Yes.
you'd say that's the end of the inquiry. They're not offering goods and services on any market. So if there was some change in the administrative structure, this often happens. You have internal governmental reorganisation. I mean,
Yes.
I can remember when the Department of Health was part of the Department of Health and Social Security.
Yes. Yes.
You say that none of that involves a relevant transfer to
No.
bring you through the gateway of 2P at
No.
all.
There can be all sorts. Exactly so, my love. There can be all sorts of changes that have an effect on you, but if they do not involve an employer engaged in economic activity, that simply doesn't avail you as far as 2P is concerned. You, of course, my lord, you may be familiar with there's the Cabinet Office Statement of Principle, COSOP, for example, which provides for central government 2P-like protection, bespoke 2P-like protection. Exactly so, my lady. And sometimes you have specific statutory instruments which govern changes, particularly in central government. But that's where there's a recognition that these things would not otherwise be caught by 2P, and it is seen by Parliament as a good thing, probably the Minister concerned, as a good thing to ensure that there is the equivalent, but there has to be a conscious decision to do so. It is not the same thing as saying that all of those situations are caught by the 2P regulations. In fact, to the contrary, the fact that they have to be done is a recognition that those things would not fall within 2P otherwise.
Yeah, and so simply to draw attention to the fact that 2P has a benign social purpose, which is to protect the rights of workers,
Yes.
and therefore should be given a broad purpose of construction. You say that may be right as a matter of principle, but it can only be taken so far. You can't just give protection to everyone.
Yes. Yes.
Even if that might be desirable.
And no doubt the government thought when in enacting 3.1b that there ought to be other people who are protected who aren't, but they are all about policy decisions being made by government, being made by the minister concerned. You have got to faithfully apply the language of 3.1a, and the language of 3.1a, you cannot get away from it. requires an identification of an economic entity and requires the identification of an economic activity. And that's where then turning on to ground two, which, as I say, I think the alternative arguments on ground one and ground two really shade in together, is that what is then said to be the need for a purpose of interpretation, you come up against Vodafone. An interpretation cannot go against a fundamental feature of the legislation. And the legislation here requires the identification of an economic activity. You cannot have an interpretation of a transfer which does not recognise that is needed. There is then the point, my lord, that as you just made to me, the avowed purpose of 2P doesn't tell you what a relevant transfer is. And it is right to say, and I think it's the claimants who've put the case of, the name of it currently escapes me. It's the working time regulations case. Harper, thank you. Harper, brain freeze moment. The claimants have put in the case of Harper, and Harper is the conforming principle case. The case which says, which the Supreme Court say, well, we think that the working time regulations were not in material respects don't conform with the directive, but not in a way that takes you below the protection of the directive, that you cannot do, but goes above what's known as gold plating. And of course, conceptually, it's right to say that it is possible to go beyond the directive, but you have to have some indication that there is an intention to gold plate. And the claimants don't actually anywhere in their skeleton argument, nor indeed in Ms Matragi's oral submissions to you today, advance any case that Regulation 3.1a has been gold plated. And to say that it could be done is not the same thing as saying that it has been done. And we say, and I certainly won't repeat myself, is that what Parliament has chosen to do is to bring in regulations which create the new purely domestic entity of Regulation 3.1b service provision changes, but left 3.1a completely untouched. That is as it has always been. And we say essentially that an economic activity is the provision of goods and services on the market. It's not ambiguous and it's not complicated at the end of the day. You have got to, whatever might be the complexities in other cases, here we say that the tribunal rightly saw this as a case, which they were perfectly entitled to do, a case about purchasing and only purchasing, and that was not an economic activity.
Scriddle, there were some criticisms made of some of the reasoning of the Employment Tribunal
Yes.
in the present case.
Yes.
You may not want to go back to that, but
Well,
or you may submit that it doesn't matter.
It doesn't matter, my lord, because what we say in relation to what the tribunal did do, sort of going back to how the tribunal deals with it.
111, wasn't it? And 113, 114
Yes, thank you, my lord.
was the passage where there was the misattribution.
Yes, and I accepted before the EAT that the tribunal does go wrong here in the sense that they attribute the quoted the italicised passage at 111 to the Advocate General. No one has been able to find precisely that passage in Fennin. And it's right to say that the Employment Tribunal are wrong when they say that the disassociation point is the Advocate General rather than the court. But we say it doesn't matter because what the Employment Tribunal did do, and they certainly were required to do this, they were required to follow the judgment in Nichols. They were bound by it. This court, of course, is not bound by Nichols, but we say that the EAT was right in Nichols in how it understood Fennin as to the limited extension to which it gives rise. And because the tribunal, as a matter of substance, got it right by saying mere purchase is not the offer of goods and services on the market, that is sufficient for the purposes of this court in terms of upholding this judgment, because the substance of what the tribunal did is correct, even though they have expressed themselves in a rather infelicitous way at paragraphs 111 to 113. And this point was picked up in the EAT itself, in which Mr. Justice Sheldon said precisely that. I'll just find it. Yes, so forgive me, page 81, paragraph 35. It records my submission that the Employment Tribunal's reasoning appears to be muddled as to what was decided in Fennin. Nevertheless, I said this did not matter. The Employment Tribunal was right to follow the decision in Nichols, which had correctly understood and applied Fennin. And then the EAT essentially agrees with that submission. Yes, forgive me, page 97, paragraph 65, where Mr. Justice Sheldon says, with respect to the claimant's further argument under this ground of appeal, that the Employment Tribunal's understanding of Fennin was muddled, I agree. Nevertheless, this did not impact on its ultimate decision. The Employment Tribunal made it clear that it was following the judgment in Nichols that commissioning by itself could not amount to an economic activity, and that the commissioner also had to be a provider. Now, of course, this court is considering the correctness of what the Employment Tribunal did, but I would respectfully endorse what Mr. Justice Sheldon says at paragraph 65 in the EAT. It may not have got it right in terms of how it approaches Fennin, but as a matter of substance, the result is correct in the Employment Tribunal. Unless I can assist any further on grounds 1 and 2.
Thank you very much. Yes, Mr. Ross.
Thank you, my lord.
Can I just remind you that you've got until 3:45, although you don't have to use all of that time.
No, I suspect I won't, my lord. Thank you for the reminder and indication. Just a preliminary point before turning to ground 3. My lord, you noted when you were asking Miss Criddle, Casey, as to the use of purchase and commission in Miss Matroghi, Casey's submissions. Just to note, and my lord, you said that that Miss Matroghi had been careful not to use them interchangeably, the two words, in her oral submissions earlier today. Just to note that within the skeleton argument, paragraph 32, which is on the internal page 11.
Yeah, I have
The appellant's skeleton argument, internal page 11, it's paragraph 32 at the top and then various Roman numerals down to number 9. 32.5, just noting in line 3, having talked about the English system of healthcare, it's got the word commission then purchase in brackets afterwards. Well, in my submission, that is consistent with the use throughout the skeleton argument, where there is not a distinction drawn between commissioning and purchasing. it's fair to say generally the word commissioning is used, but there is no attempt to distinguish the two from each other. Having made that preliminary point, I'll turn to ground 3. It's fair to say, which is probably indicative of the time it was given by the appellants, that ground 3 is probably an academic ground. The claimants accept at paragraph 61, or certainly they appear to accept at paragraph 61 of their skeleton argument, which is internal page 21, that it's only if economic activity were construed to include commissioning activity connected with the market that ground 3 that alleges a failure to properly engage with regulation 3.5 of the GP regulations is engaged. And that therefore the respondent's primary position on this ground is it's an academic one, because the construction that the claimants contend for is wrong. Essentially, Mr. Justice Sheldon dealt with this properly in the Employment Appeals Tribunal. Perhaps I can ask the court to turn to his decision, which is at page 97 of the core bundle.
Yes.
And in summary, what's said at paragraph 66 at the bottom of page 97 is that having decided that the activities of NCCCG didn't constitute an economic activity, there was no need, therefore, for the Employment Tribunal to go on and determine whether or not Regulation 3.5 was satisfied by using what's described as the checklist of factors of Mr. Justice Lavender in Nichols. Perhaps I can invite the court to turn up Regulation 3 of TUPE, page 19 of the authorities bundle, and this picks up on the question about where ancillary activities comes into the definition, which my Lady Justice Laing raised with Ms. Criddle. It's at 3.2, and you can see at the end of 3.2 the words whether or not that activity is central or ancillary. But looking at Regulation 3.1a together with 3.2, which is a necessary definitional addendum to 3.1a, and Regulation 3.5, there are clearly multiple routes in my submission to showing that there was no transfer under Regulation 3.1a. And Ms. Criddle has already touched on some of these earlier today. So one possible route, looking at 3.1a itself, is showing that there is an economic entity that transfers, but it doesn't retain its identity. And so the end of 3.1a is inapplicable and the test is not met. Another route would be showing that what transfers wasn't an economic entity, because looking now at 3.2, there wasn't an organised grouping of resources. Another route would be showing that although there was an organised grouping of resources, that organised grouping didn't have the objective of pursuing an economic activity, be it a core or an ancillary, rather central or ancillary economic activity, to use the exact words.
Why isn't it an organised grouping of resources?
Apologies, my lord.
Why isn't it? You said one way about responding to this was you said that it wasn't. So
My
why
lord,
isn't a commissioning group
apologies, my lord.
organised grouping of resources?
I hadn't mean to suggest that it isn't. This is mere hypothetical means in the abstract, my lord. I'm not suggesting that the CCG wasn't. These are just some routes in the abstract of showing that there wasn't a relevant transfer.
Thank you. Sorry.
No, not at all, my lord. Then into Regulation 3.5 itself over the page, the clarification that either an administrative reorganisation of public administrative authorities on the one hand, or the transfer of administrative functions between public administrative authorities on the other. are not relevant transfers. That's two further routes to showing that there wasn't a relevant transfer. There are no doubt more. These are just illustrative examples. And in my submission, any of those 5 possibilities that I've just outlined are sufficient for there not to be a relevant transfer under Regulation 318 in the abstract. There is no need to do any cross-checking if you have satisfied yourself as an employment tribunal for any of the first 3 reasons that there wasn't a relevant transfer. There's no need to go on and look at Regulation 3.5.
So you could express it as 5 criteria, each of which has to be satisfied, all of which have to be satisfied, in order for it to be a relevant transfer.
I would put it in the negative, my lord, and say, on the contrary, there are at least 5 routes of showing that there wasn't a relevant transfer, and each of those is logically sufficient without reliance on another one. And so if, as a tribunal, you get to the end of one of those factors, say, in this case, that there was no economic activity being undertaken, that's the end of the matter. You don't need to go on and satisfy yourself about the organised grouping of resources question or whether or not there were public administrative functions being undertaken, because you've got a sufficient answer to the question. And we turn now to what was actually decided in this case, which, my lord, you were gesturing towards quite properly. It's 105, paragraph 105 of the Employment Tribunal's judgment, page 126 of the core bundle. And in the 4th line of that paragraph, the tribunal says CCGs do not, and NCCCG did not, supply goods or services on a market. It was not without more undertaking an economic activity. And having made that finding of fact, which in my list of examples was the 3rd of the 5 example routes to finding there was no relevant transfer, nothing more was required of the tribunal than that. It was therefore permissible for the tribunal to decline to consider the 10 relevant considerations from Nichols. And you can see that's what the tribunal did by turning to page 127 and looking at paragraph 114 at the bottom of that page. It's clear that the tribunal has turned its mind to those 10 relevant considerations, but it's decided it's not necessary to consider them substantively. In the claimant's skeleton argument at paragraph 66, they say that the tribunal failed to direct itself to the relevant considerations. But in fact, that's the 3rd line of paragraph 66. But in fact, what the tribunal did is it simply found it unnecessary to engage substantively with those considerations. And on the suggestion that this is a checklist, the respondent's position on that is that Mr. Justice Lavender merely identified 10 relevant considerations without purporting to set out a checklist, which would have to be gone through factor by factor. The respondent disputes the contention at the end of paragraph 61 of the internal page 21 of the appellant's skeleton argument that had the tribunal applied the law correctly on their case, having gone through those 10 factors, 10 relevant considerations in Nichols at paragraph 55, there was only one possible conclusion that could have been reached. The tribunal didn't make findings of fact. It's unclear whether or not this is pursued, but if it be pursued, given that the tribunal hasn't made findings of fact, it would necessarily be required for the tribunal to do so, or a tribunal to do so, and determine the Regulation 3.5 issue for itself, having made findings of fact. I mean, finally, on this ground, very briefly addressing the approach to Regulation 3.5 and how strictly it should be construed, which is something that's touched upon by the claimants at paragraph 69 of their skeleton argument, which is on internal page 24 of their skeleton argument. essentially, the claimants take issue here with with Mr. Just Lavender saying that he wasn't persuaded that it was helpful to describe the public administrative functions exception, or the Henker exception, as subject to a strict construction. That is an academic issue in this appeal, because the tribunal didn't rely on whether or not it was a strict or not a strict construction at all, and therefore it can't be an issue. However, if the court did consider that the issue of how strict the Regulation 3.5 analysis should be, we have addressed that in our skeleton argument at paragraphs 52 to 53. That's great.
If you're about to move on from ground 3, can I ask you for your assistance, because we may have to say something about Mr. Justice Lavender's judgment in Nichols. In fact, we're being invited to overrule it, although it's been clarified that only refers to part of it. But I have to say that I'll have to look at it again. I've read it many times, but I'll have to look at it again. I am myself left wondering why Mr. Justice Lavender felt it necessary to say what he says at paragraph 44. And there's a lot of paragraphs which then follow, and he says, I'm now going to pull together some of the threads from the authorities, and then he explains that there are two mutually exclusive alternatives, and they are economic activity and the exercise of public authority. And then I have to say, employment tribunals might be forgiven for thinking that they are required to embark on the exercise, which begins at paragraph 52. But that's all to do with Regulation 3, paragraph 5. And as you've explained to us, Mr. Ross, actually there are many other ways, potentially, in which something may not come within the scope of economic activity in the first place. So it may or may not be necessary to rely on Regulation 3.5. And then, as you say, there's the so-called checklist at paragraph 55, although Mr. Justice Lavender makes it clear at 56 that these are all relevant considerations, none of them is definitive, it's not necessary and sufficient for finding that an activity involves the exercise of public authority. All I'm suggesting is that whatever we say about this, because this is the Court of Appeal, and it's the first time I think we've had the opportunity to consider this case, although it's 6 years old, we may have to say something about this. And if you're able to give us any assistance on whether we should simply endorse what Mr. Justice Lavender said, or whether we should take a more nuanced approach.
Yes, my Lord, the respondent doesn't accept that there are two mutually exclusive categories, and Ms. Goodall has set that out, partially by reference to the academic literature, but not exclusively, also by reference to the CJEU case law. So we don't agree with that. The case itself and the factors, it's probably worth drawing the court's attention to paragraph 64 on page 627, and to some extent this perhaps tidies up the ancillary economic activity question, to the extent that that is still a live one. So in this section of the judgment, Mr. Justice Lavender deals with mixed cases, some of which a transferred entity, which may or may not be economic. There are some activities that are economic in nature and some which involve the exercise of public authority. In that case, you have from Regulation 3.2 TUPE something that says that if an entity is carrying out economic activities of an ancillary nature, that is sufficient to make it an economic entity on the one hand, but also on the other hand, you have Henker that says that if it's carrying out activities involving the exercise of public authority, then if they are ancillary activities, then that doesn't change the result. You can still fall within 3.5, and that's being quoted at the end of paragraph 64. that paragraph 17 of Henker that says that. And so it follows that if there is an entity which is undertaking a mix of activities, then it will be necessary to decide whether or not there are ancillary economic activities or something that goes beyond that. Because if it goes beyond merely ancillary economic activities, then that would take it outside of Regulation 3.5, arguably, and therefore mean that you couldn't avail yourself of the different position to ancillary economic activities in Regulation 3.5. So, my lord, the short answer to your question is that in a mixed case, it might well be more complicated, but in this case, it's not a mixed case because of the tribunal's findings of fact, which is essentially ground 4 and ancillary economic activities. The tribunal's conclusion, as Ms. Griddle's already foreshadowed, is that nothing was economic. There were no ancillary economic activities. And therefore, that's why there wasn't a need to go through this Regulation 3.5 process. And that's why it wasn't necessary to go through the list of 10 considerations, or indeed a broader consideration of whether or not there were activities which involved the exercise of public authority. That's the respondent's position on Nichols. My lord, are you content for me to move to ground 4?
Yes. Well, I thought you had.
I suppose I started weaving in some of ground 4. But to address the criticism against the tribunal, it's necessary in my submission to look at paragraphs 97 to 104, which lead up to the ultimate conclusion at paragraph 105, and that's found. Those paragraphs are found at page 124 of the core bundle. Of course, the header of the section is functions of the NCCCG. Paragraph 97 is essentially an introductory paragraph, and the first part of paragraph 98 is really the statutory background. But once you get into line 4, you get a clear description of what the CCG was actually doing until the end of paragraph 98. And there's a clear summary of what the tribunal regarded as the core function of CCGs in paragraph 101, which helpfully, in my submission, summarises what's said, particularly at paragraph 98. And that's to arrange for the provision of health services. Beyond paragraph 101, there are further activities which one might describe as ancillary. There are the finance, HR, data management activities mentioned in paragraph 102. In 103, over the page, there is the point about training. Ms. Matraghi says that that's wrongly recorded, but for present purposes, the court will have to take what's said there at face value in my submission in terms of training, signposting patients to relevant services, and undertaking some other peripheral matters. That is an outline of the different activities that the CCG undertook, both core and ancillary. When one reaches the conclusion under the next heading about whether or not the CCG carried out economic activity, which is at paragraph 105, the conclusion which you've already been referred to is that CCGs do not, and CCG did not supply goods or services on the market, and it wasn't without more undertaking economic activity. On a fair reading of that section of the judgment, what the tribunal was saying was that none of the activities, be they core or ancillary, amounted to undertaking an economic activity. In the respondent's submission, it's not a fair reading to allege that ancillary functions remain somehow unclassified or unconsidered. And the ultimate submission on ground 4 is therefore contrary to what the claimants say. The tribunal didn't fail to consider the CCG's ancillary functions, which is charge 1 really of ground 4, and they didn't fail to apply the regulation 3.2 definition, which is charge 2. My lord, unless I can be of any further assistance.
That's very helpful.
Those are
No
my
check. Is there any questions? No? Thank you very much. Yes, Mr. Charles.
So I'd like to start by addressing the point on economic activity. As I said, this is the core issue. And lest it be misunderstood, we're not asking for the court here to put economic activity to one side. We're not asking for some sort of freewheeling interpretation of purpose. Our argument is that commissioning is capable of being an economic activity in a broader range of circumstances than Nicholas has recognised. I think that goes into a number of points. I think it shades into, first of all, the pleading point. It's been suggested that the respondents are surprised that we refer to commissioning as being something other than simply purchasing. But the tribunal's own judgment refers to commissioning being planning, purchasing and monitoring. So we say that it couldn't be understood by the respondent and wasn't understood by the tribunal that all that the CCG was doing was purchasing.
Sorry, where's that quotation come from?
Yes, now the quote, it comes from paragraph 99 of the judgment of the tribunal.
Thank you.
And I think what happens is the tribunal then collapses the meaning of commissioning into purchasing. So it says commissioning is, it's page 125. Commissioning is essentially the process by which health and care services are planned, purchased and monitored. It's a life cycle. So one is first deciding what are the services that we need. Do we need 5 hip replacements? Do we need 500 hip replacements? Should we be instead offering people injections rather than having hip replacements? Should we be offering them exercise?
I mean, you say in effect then, when the ET goes on to say, so in this context, commission means buy.
Yes.
That's too reductive.
That is too reductive. That is far too reductive. So, and as to the point that, well, actually this is all news to us, this wasn't something that was set out below. In fact, it was absolutely part of the appellant's submissions at the ET that one needed to look at the commissioning services themselves. And indeed, if I can just take you, you don't have it in front of you, although I have copies which I'm happy to hand up to the court. At paragraph 25 of the submissions to the Employment Tribunal, it said this, and I'll just read from it directly.
I think if you have copies, it would be helpful
Yes,
for
certainly.
us to receive them.
Certainly, yes. So when setting out what it was that the CCG was doing, we made reference at paragraph 25 to self-employed medical practitioners are treated as undertakings under EU law and so are engaged in economic activity. See Pavlov, case of the CJEU in 2000. In other words, the respondent's own position is in fact that the services and expertise of clinical advisors for commissioning and advice purposes can be and are supplied via private independent contractors. This provides strong evidence that the commissioning activities of the CCGs themselves are an economic activity quite apart from the final use of the services being purchased as per fame. So what was being said there is when Dr. Bicknell or another clinical advisor is providing advice as to what should be the correct clinical pathways, as to, in this example, I'm not saying it's a real example involving Dr. Bicknell, how many hip replacements would be needed in this locality, who they should go to try and obtain them, under what sort of terms, etc., etc. That is clinical advice that is being provided, and that is a service, and that is an economic activity, and it is one that is capable of being provided on a market, and indeed was being provided on a market, because this case is in part about the fact that these CCGs, some of them were going out to other people to get the clinical advice, whether they were individual doctors or an organisation called Centene, which they used, or indeed other organisations like Deloitte that they used. And this CCG was using some of those services, but they decided that rather than having Dr. Bicknell employed as an employee to provide clinical advice services in commissioning, they would instead move to a model where they just had self-employed people doing that, providing those services. So it could not be clearer that there is a market for commissioning services. As my Lord Justice Baker made the point, one wasn't simply opening the yellow pages,
No.
and the provision of advisory services in the planning, purchasing, monitoring, contract management, evaluation, whole life cycle of commissioning is very obviously a service.
This paragraph before 1999 comes 98, which refers to the relevant system of the statutory system.
Yes.
So this is the so-called Lansley reform, is it? That replaced primary care trusts.
Yes, I didn't know it was called the Lansley reform, but I'm very
Probably
happy to
long
take
before
it.
your time. It was introduced by the coalition government to replace primary care. There was a lot in. So presumably there is somewhere defined in either the Act or regulations or something under the Act, guidance or something, what commissioning involves.
Well, yes, indeed, we do have.
And it says, presumably, it doesn't involve just looking at the yellow pages and finding a provider.
Quite. I mean, we don't have an exhaustive account of this, but we do have in the supplementary bundle, we've got functions of clinical commissioning groups. And the functions of the clinical commissioning groups includes commissioning responsibilities at page 7, and that sets out that for some services the costs for an individual patient will be charged to the CCG where the trust patient is registered, for others not. It sets out that the CCGs will be responsible for commissioning healthcare services to meet the reasonable needs of persons for whom they are responsible, and then it lists a range of areas where they will be responsible: community health, maternity, elective hospital, rehab services, older people services, infertility, wheelchair services, and sets out that those services are to be provided free of charge other than in limited circumstances where charging is.
And presumably the commissioning is for a time-limited period. I mean, is there a provision about probation, renewal,
All
monitoring, appraisal?
Of course.
Oh, sorry, you said, of course.
Yes, well, indeed, that
So-
that must be right. And just to deal with the point that's been made that, well, I think it was said that parts of our skeleton, I think it was internal pagination 3 to 5, were not accepted by the respondent here. That comes as a real surprise to us, because those are the things that were conceded before the Employment Tribunal in front of Employment Judge Brewer, and indeed are recorded in the written submissions of the claimants, saying that this was the particular situation and it has been conceded. So we say we simply don't understand how it could be said that that actually this is an organisation that doesn't do any services, not any economic activities. All it's doing is just purchasing, because there are institutes, there are thousands of people, there is an entire sector who are involved in the complex business of commissioning, which goes beyond simply what procurement departments would do, but that evaluation, monitoring and so on. So we say that that is a very important point, and one which the ET didn't wrestle with, and that the respondents' submissions on this are not, should not be accepted.
Why does this expanded meaning of commissioning to go beyond buy mean that it's an economic activity?
Well, that's a good point, and it can be answered by reference to Nichols itself. So Nichols was a case about a public health team, and it was a circumstance where the public health team were being transferred, but was it a transfer for the purposes of TUBE to the council? Now, in this case, slightly different, because of course the CCG says, no, none of these people, we're not accepting any of these people are moving over, it's not a transfer. But in the public health case, they moved them over and then they wanted to downgrade terms and conditions, to which they objected or resigned or indeed were dismissed. And we can see, lest it be thought that a market means that one actually had to have already sold your services on a market. That's not what's required. So if we look at Nichols, just bring up page reference. I think we can deal with this partly by looking at the tab 34, for those who are able to get there before me.
34.
34, yes, it begins at 609. So we can see, this is in the head note, but this is a good place for me to start. Claimants are employed by a primary health care trust, transferred to the respondent council, and then you'll see about halfway down, the middle of the page, it says the tribunal found the public health team's activities included the exercise of public health functions to improve the health of the community, and while it did not bid for contracts, it was involved in commissioning sexual health services, research, training and the maintenance of a public health library, all services offered by non-state actors operating in the same market. And then the tribunal go on to say that paragraph at the next page, when the appeal is allowed, they say that the tribunal should have adopted a function-based approach and considered whether particular activities exercised by the specific entity being transferred constituted an economic activity, meaning the provision of goods and services on a given market, even if provided free of charge and without a view to make any profit, or the exercise of public powers, and then I don't need to go further than that. And then secondly, the tribunal's finding that almost all of the work done by the public health team was offered by non-state actors operating in the same market was a strong indication that the public health team was carrying on an economic activity. Now, here, of course, this is a similar point. There are all these other organisations that were accepted in this case as being able to provide these clinical commissioning services, which included Centene, it included other independent contractors, it included the way in which the other CCGs were operating, with people simply on contracts for services providing the clinical advice for commissioning, and so on. So this too was a case where there were non-state actors who were providing those services. Some of them for profit as part of a limited company or PLC, some of them as independent contractors. So those were services that didn't have to be, wasn't that the only place you could get those services was via the CCG. You could go and find somebody like Dr. Bicknell who would provide you with those services and say, I know how many hip replacements you should be purchasing, and I know the best way in which to commission those services, plan, purchase, monitor, evaluate, monitor, and back again. So in circumstances where these are similar cases, Nichols and the CCG, insofar as we look at the commissioning element and the existence of these non-state actors. And we see that in Nichols, Mr. Justice Lavender says, well, this has not been properly looked at. Why is it, if there are these non-state actors involved, that this is not indicative of economic activities offering goods and services on the market? So that's That's the first point. Then, of course, in relation to the downstream use of the services, if fenning means that you should be looking at the downstream use of the HIP operations that are actually ultimately commissioned, or the IVF services, or what have you, there's no consideration of that, because the employment judge in this case said, well, that's just an Advocate General's opinion, I don't need to look any further at it. The dissociative approach is the correct approach. If we look at economic activity, if I'm moving on to a separate point, economic activity does have a variable meaning in European law, which is sensitive to the context. I'm not suggesting for a moment that one shuts one's eyes when there is a competition law case, or that in competition law that they wouldn't be entitled to look at a cheapy case, or indeed a case under the 6th Council directive on that, or indeed under Article 49 on freedom of establishment. But one has to be sensitive to the context, and that isn't in some sort of airy-fairy, it's cheapy, let's all just look after workers. It is because what we are looking at is, as my Lord Justice Singh has said, we are looking at the words of the directive and we are reading them in their proper context. And we get a sense of this in Fennin itself. If we look at page 325 of the Authorities Bundle, so at page 325 of the Authorities Bundle, AG 51 actually starts at 324, but the part that I need to take you to is not on 324, it's 325. There is a distinction being drawn there between how competition law applies and how Article 49 EC applies. And it says, by contrast, the way in which an activity is organised at the national level has no bearing on the application of the freedom to provide services. Thus, although there is no doubt that the provision of healthcare free of charge is an economic activity for the purposes of Article 49 EC, it doesn't follow from that that the organisations which carry on that activity are subject to competition law. So we say, and I'm conscious this is a reply rather than a full exposition of the submission, but there are different contexts where one is, even within European law, where one might find economic activity has one shade of meaning and in another economic activity has another. And so if we go back to the ICAEW case involving Lord Justice Belden, that's the case involving the EU 6th Council Directive on VAT. That is of course a case of this court. Lord Justice Belden concludes at 175 F to H that the concept of an economic activity is an activity that's typically performed for a consideration and connected with economic life in some way or another. But it's not an essential characteristic, it be carried out with a view to profit or for commercial reasons. An activity which consists in the performance of a public service to which the idea of commercial exploitation with a view to profit or gain is alien is not of an economic nature, particularly where that activity is one of typically of a public authority. We say that that is an entirely proper way to look at the economic activities in this case. And of course, the services that were being provided, if one looks at the commissioning services, when Dr. Bicknell is, instead of being an employee, either he or one of his colleagues is being asked as a self-employed contractor, tasked with looking at the planning, purchasing or monitoring of particular healthcare services, maybe IVF, maybe hip replacements, whatever. And that isn't a service to where it is where the idea of commercial exploitation with view to profit or gain is alien. That's something that's already happening. That's something that dozens of commercial companies, both in the big four and indeed in specialist healthcare consultancies and advisory organisations are already providing. So lest it be thought that we, as I say, that we think there's some sort of freewheeling interpretation to TUPE, we fully accept that TUPE has limits. And when it comes to economic activities, I've touched on that. And the court, the control here, when we're looking at these activities, is looking at whether or not these are economic activities, or, as Justice Belden says, whether these are connected with economic life with a view to profit or for commercial reasons, even if performed freely, but not one to which a concept of profit or commercial exploitation is alien. Now, very obviously, that would exclude things to do with core state functions. And indeed, we see that in the Nichols case, where Mr. Justice Lavender has set out the sorts of things that need to be taken into account in that case. So if we go back to tab 34609 and specifically to 625, that's
Para 55.
Para 55.
It's 10 points.
Yes, the 10 points. Is this activity, 55.1, is this activity necessarily carried out by public entities? Well, of course, these activities are not necessarily carried out by public entities. We know there are all sorts of commercial operators who are undertaking these activities. Secondly, whether the activity is a core state activity, well, it's nothing like a functioning judicial system or a police service or indeed operating of roads. Thirdly, whether the activity has been carried out by public entities.
Has always been carried out.
Has always been carried out by public entities. That this isn't the case that these things have always been carried out by public entities. Fourthly, whether the exercise involves the exercise of prerogatives outside the general law or privileges of official power. Well, no such matter applies here. And I should say, none of these submissions are new. These are the submissions that we made and did so in writing before the Employment Tribunal. Whether the activity involves the exercise of rights and powers of coercion? Well, clearly not. This isn't like a police force or, like I say, judicial system. Whether the activity is a public service to which any idea of commercial exploitation with a view to profit is alien. That is something that comes from Eurocontrol and couldn't be conceivably carried out within a competitive system. That's from Diego Cully. So it's not just Lord Justice Belden in that case of ICAEW who is making these points about commercial exploitation with a view to profit being alien as a potential control factor. Whether the activity has an exclusively social function, well, clearly here that's not even being argued and wasn't below. Whether the activity was typical of a public authority, well, of course, this was not some sort of unique function that was being carried out, a unique activity. As my Lord Justice Singh has already said, this is the same sort of activity, albeit with a slightly different flavour, to that which was carried out by Apple when undertaking its own large-scale procurement. And then whether or not the activity is carried out in the public interest, well, yes, one might say no, perhaps where it's charging, but others would have different views on that. And whether the activity involves providing services in competition with those operators pursuing profit.
On the Apple point, I think what Ms. Criddle would say is that Apple is undoubtedly providing goods and services on a market itself.
Yes.
So it's not merely that it has a commissioning department.
Yes. Well, but of course that's the same situation, my lord, with the public health case of Nichols. So in Nichols,
that I understand. Yeah.
Yes.
Yeah. I just wanted to
yes, and of course
caveat
there are
on the
companies.
analogy with Apple.
Yes, indeed, there are companies who specialise simply in procurement. So it's not that the only way in which procurement happens is if you've got a huge entity and then you've just got a procurement department on the side. Procurement is such a specialised area, and I mean it in that. I don't mean in the sense of opening the yellow pages, just buying something. In the broader sense, in the sense where we are talking here about commissioning, where you are deciding what to buy, buying it, and then monitoring and evaluating it. So one seems to have, the tribunal didn't engage with that at all. So we say that that is something that self-evidently should fall within offering goods and services on the market. It doesn't have to be that it has already been exploited. It's about whether it is something that is capable of being so, and that's why in the Nichols case it was remitted back, because of the existence of these non-state actors who could do the same as the public health team. So that I think deals with the first points I wish to address. Yes, the point about non-distortion of the market. Most European law, as my Lord Justice Singh has observed, derives from or is connected to the fact that there is a common market, and it is about one of the purposes of much, if not all, of the directives and legislation and actions is to ensure the proper functioning of that internal market. But the fact that it's concerned with the proper functioning of the internal market does not mean that there aren't other priorities as part of that project: consumer law, environmental law, free movement law, employment law, and in particular QP. So we say that it isn't some sort of slam dunk point to say, but we've got to think about competition because of the functioning of the internal market. That is a sort of so what point, in the same way as we might say, well, law is there to regulate human behaviour. Then I'd like to turn, please, to the...
I'm sorry to labour this, and it may be a bad point. I'm not sure it's quite as straightforward as that. Historically, the vagaries of what was then called the European Economic Community, later the Union, their vagaries were limited by the fundamental characteristics of the entity, which the supranational legal order which had been created. And in the 1970s, for example, things like discrimination legislation had to be justified by reference to the fact that otherwise you would have a distortion of the internal market, because otherwise some people would have an unfair advantage in competition. So, of course, they had a benign social purpose, but it all had to be anchored. Now, later on, the competence of the EU organs was expanded, which is why, after Maastricht and so on, they were able to engage in things like home affairs issues. And later still, in things, you begin to see developments even in the field of foreign affairs, potentially. And there was the famous social chapter, which extended the competence of the EU, which is why you then get much more openly things like employment and similar legislation.
Indeed, and the fundamental charter, which is referred to in the 2001 directive. So I'm not saying, forgive me, what I'm saying is that non-distortion of the internal market is the backdrop to a lot of the EU, law. But that does not mean that competition law is in some way prime when looking at the meaning of economic activities.
No, I think the submission only goes to this extent. Ms. Criddle says that it's legitimate to refer to the competition case law.
I have no problem with that. I have no problem with that in the same way as it is legitimate to refer to the ICAEW case and the decision of Lord Justice Feldham, and indeed it would be legitimate to look at if there is jurisprudence in relation to Article 49 or any of the others which deal with a definition of economic activities. But one must, adopting the modern approach, which my Lord Singh has already referred to, look at this in its context. And the context here is twofold, that there are services being provided by Dr. Bicknell and others within the CCG in connection with the planning, purchasing, monitoring, evaluation, full life cycle of the commission services of this organisation, and also following Henke, if Henke is, Fennin, if Fennin is to apply, one looks at the downstream use of the things that they did in fact obtain for the CCG on behalf of the local population they are serving. And then lastly, if I can come to how far does Henke go? Well, we looked at the example of the Ministry of Justice. I did say that it's a fact-sensitive analysis and it will depend on time, place, evidence and so on. But I think it's fair to say that we could be pretty confident that we could rule out judges and police officers because of the nature of the core state activities. They might well also be in the scope of the Henke exception. So, but the case of Dr. Bicknell is nowhere near that. For the reasons that I've already mentioned, these are not core state functions. This is at the other end of the spectrum. This is about having a more business-like approach to the obtaining of these healthcare services. Thank you very much.
May I just check if there are any other questions? No, we're very grateful, not only... Oh, sorry.
My lord, I'm so sorry, but just to raise one point. I didn't interject because it's usually not helpful to the court to do so. However, in reply, Ms Matraghi proposed giving you her written submissions below. My lord, you have points that we've made that the question of commissioning itself as an economic activity is not part of these grounds of appeal. My lord, I'm not going to object as such to you seeing the submissions, but I ask that you look at them de bene esse, subject to making a decision about the scope of this appeal and whether those matters are relevant considerations to the appeal as pleaded.
If I might just return on that small point, Ms Cribble reminds me of one point, which is we say that it's this point about what commissioning are commissioning services themselves, economic activities. I've said where it is that we put that in our written submissions before the ET, and we say that falls firmly within ground 2 of the appeal in this case, in terms of construing the concept of economic activity within this case. So we don't accept that it isn't a part of the case.
Do you have copies? Or
yes.
your submissions before the ET?
Before the ET, yes.
If you have hard copies,
Yes.
then I suggest that you hand them up and we will look at them de bene esse and then we'll adjudicate on this procedural issue, if necessary, in the course of giving our judgments.
Thank you very much. I think I've said already, it's paragraph 25 of that which refers to commissioning as a service itself. And also has the points on metals and public powers and so on.
Now, I'd like to thank everyone, not only the advocates from whom we've heard, but everyone who's assisted in preparation for this appeal. We will reserve our judgments now. Drafts will be circulated in due course to those counsel and solicitors whose details have been provided before the hearing. I have a list of those. And I do stress that this is for the purpose only so that any typographical or minor factual errors can be drawn to our attention. And we would hope that the parties are able to agree a draft order If they can't, then they should file brief written submissions with a view to an order being finalised at the same time as the hand down of the judgment, which of course does not require further hearing in person or any hearing at all. I do stress, as this court has frequently done since the Counsel General for Wales case, that circulation is for those limited purposes only, and breach of the confidentiality embargo is taken very seriously by this court. Unless there's anything else. Thank you.
All rise and able.
I did write you a follow-up, which I thought you probably didn't need, which you would have.